If you're looking for answers to action over insurance questions, you've come to the right place. Far too often, action over questions leave contractors with big insurance bills and no answers. But hopefully, after watching this short video or reading the article below, you'll have the answers you need to be informed. So what is action over and why does it matter so much here in New York? Well, the short answer is scaffold law, action over, all has to do with Labor Law 240 and 241. These two laws impose liability like no other law on building owners and general contractors here in New York. The one-sentence version, you're held responsible regardless of who's at fault. It's called absolute liability, but that's kind of a legal term. But for insurance purposes, basically you, the general contractor, you, the building owner, can be held responsible regardless of fault. Here's something really huge and, kind of the reason that it's such a problem here in New York is the only state with this law. Illinois had one, they got rid of it years and years ago. Basically, workers' comp has replaced the need for this law. So the big question is, how much does action over cost? Well, action over costs everyone in all ways. From the project owner / developer, costs them more on the construction, you as the contractor costs you more on your insurance, and even costs taxpayers more money for public works projects. The worst part? Most of those costs aren't even the settlements. To shed a little more light on that, our friends over at Taliesin Construction said it exceptionally well. The risk management costs of Labor Law 240 far exceed the amount paid to any worker who was injured in a gravity-related construction accident. Yeah. Basically, that means the insurance costs are way more than anybody who's injured is actually going to put in their pocket. Now, that's not to say the settlements are insignificant or inexpensive. They are, on the other hand, quite expensive. In fact, more than 50% of the most expensive lawsuits here in the state of New York were related to action over. Now, most insurance companies actually don't go to trial, they look to settle. And that is due to the very broad wording of Labor Law 240 and 241. It essentially makes defending claims a monumental task that nobody wants to deal with. The broad wording also makes the law applicable to things that it wasn't really designed to be applicable to. And the last thing is, back on the settlements, the insurance companies just don't want to risk what a jury might assign for someone who's injured. Because that's not to say these workers aren't injured. They are definitely injured, but they've been reimbursed and taken care of by workers' comp, the device that's in place in every other state to take care of injured workers. This is above and beyond. That's another reason it's called action over. So what does that added risk management cost add to a typical project? Well, on average, it adds around $10,000 to a single family home construction. So that means your average home is gonna add $10,000 just for the additional insurance related to action over coverage, which is nuts. A single family home isn't even that big of a project. On a larger scale project, that dollar figure is even higher. Because on average, New York contractors pay 10 times what contractors pay in other states for their general liability policies. So going back to what I hinted at the beginning, who's affected by workers' comp? The short answer is everybody. The taxpayers pay more for public projects, homeowners pay more for renovations and new construction, developers, general contractors, everybody pays more because of action over. Another big factor is some smaller trade or artisan contractors really just can't afford action over coverage, and then they're left dealing with less than ideal projects, less than ideal insurance coverage, all due to the cost of having the right insurance coverage, including action over. So what's the fix for this huge problem? Well, there isn't a good one, but there's two main fixes that you can do to kind of prevent or temper the financial situation here. The first fix is making sure that you, the general contractor, or anyone who hires subcontractors, uses proper risk transfer to those subcontractors. Essentially, that means you have an ironclad risk transfer agreement, also known as a subcontractor agreement. Now, that makes sure that you are indemnified and held harmless by that subcontractor who's actually doing the work. That's huge. Step number one, highly recommend you contact an experienced construction attorney who can draft that document for you. So the second fix to the huge action over problem here in New York is working with other contractors, politicians, insurance companies, etc. to reform the law. Without reform, the insurance premiums are just going to continue to rise here in New York and eventually push out even more contractors, because the premiums are just at a borderline unsustainable cost right now. A great way to get involved is scaffoldlaw.org. They have an action committee. They have people up in Albany that are actively working on this, but they need your support to actually implement change in the law. So bottom line, if you're not sure if you have action over coverage, or if someone's asking you about action over coverage, feel free to give me a call, shoot me an email. I'd love to chat about it. You really need to be aware of what your coverage is, what the limitations are, and honestly, if you have employees, if you're doing work for a contractor, you really do need to have the coverage. And by the coverage, I mean action over.